I have been practicing workers' compensation law for 20 years now. I started out by practicing as an attorney for insurance companies and employers, and learned a lot about how employers and insurance companies think about injured workers and think about how to reduce their costs for workers' compensation. And then I had the opportunity to come to this firm, work on behalf of union members to protect their rights under workers' compensation. And the good thing was that I had this base of knowledge about how employers think about workers' comp to come and use that knowledge to the advantage of injured workers. So workers' compensation is specifically for injuries that occur at work. Way back in 1913, the legislature created the Workers' Compensation Act, and it is a no-fault system. What that means is, it doesn't matter whether you were at fault for your injury, doesn't matter whether your employer was at fault for your injury. Any injury that occurs during the course and scope of your employment should be covered under workers' compensation. Now, what workers' compensation covers is time missed from work and medical expenses related to the treatment of work injuries. So workers' compensation does not cover things like pain and suffering, and that's because it's a no-fault system. It used to be, before workers' compensation laws existed, if you got injured at work, you had to sue your employer for negligence. You had to go to court, you had to prove that they were responsible for your injury, and maybe 2, 3, 4 years down the road, you might get some compensation for that. So when they created this system, what they gave to injured workers is an expedited system, a system that can get people paid quickly. What injured workers gave up was the right to benefits like pain and suffering. So I get questions practically every week about how do I sue my employer? You can't sue your employer. The only right that you have when you are injured at work is, and it's confined only to your employer, is workers' compensation. Sometimes, and it probably doesn't apply to you, but I'm going to bring it up anyway, sometimes employers have vendors who are responsible for things in the workplace. For instance, they might have a vendor who clears snow on the sidewalk. They might have vendors who do cleanup, waxing the floors and things like that. If an injury that happens at work is the result of a third-party vendor, not your employer, let's say that somebody delivering milk to the school spilled milk and didn't say anything, not only can you get workers' compensation from your employer, but you can sue the third-party vendor for pain and suffering, for wage loss, for your medical expenses. Now, workers' comp gets anything they've paid you out of the proceeds of that lawsuit. So it's not necessarily a double recovery, because workers' compensation has a right, it's called subrogation, where they get any money they paid you if you did have a third-party lawsuit. So just keep in mind that, unfortunately, workers' compensation covers two things: wage loss benefits for time missed from work and treatment for medical expenses.